Next up on This Week in Law, Louis Villa and Stephen LaPorte joined Sarah Pearson and me to discuss the Ad-blockalypse, the TPP, the GPL, Oracle versus Google, and how wanting to be forgotten can get you Streisanded instead. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise, Howell, and Sarah Pearson. Episode 323, recorded October 9th, 2015. 50 Shades of Streisand. This episode of This Week in Law is brought to you by FreshBooks, the super simple cloud accounting software that's giving thousands of freelancers and small businesses the tools to save time billing and get paid faster. Try it free at freshbooks.com/TWiL. And by Braintree. If you're working on a mobile app and searching for a simple payments solution, check out Braintree. With one simple integration, you can offer your customers every way to pay, period. To learn more and for your first $50,000 in transactions fee-free, go to braintreepayments.com/TWiL. Hi, folks. Denise Howell here, and you're joining us for This Week in Law. I'm very, very thrilled to let you know that Wikimedia is in the house today. Not once, but twice. Two great guests from Wikimedia are joining us. Louis Villa is the Senior Director of Community Engagement at Wikimedia and a lawyer in his own right, though he's wised up and is no longer practicing these days. Great to have you on, Louis.
Thanks. Great to be here.
And still in the grips of being a member of the bar is Stephen LaPorte, who is counsel for Wikimedia. Hello, Stephen.
Hi.
Great to have you on. Also here is my co-host, Sarah Pearson, also guilty of being admitted to practice law. She is senior counsel for Creative Commons. Hello, Sarah.
Hey, Denise. I'm excited to be here with these two folks who I work with a lot, actually, in my job. So
that's
it'll
awesome.
Be fun to chat. Yeah.
Yeah. Well, why don't we start with that before we get into our stories in our rundown for the day. I'm interested in the interplay between Creative Commons and Wikimedia. How is it that you guys wind up working together?
Well, Wikipedia is all under a Creative Commons license. So they're probably our biggest, I don't know, I think it's fair to say our biggest adopter in the world. So they're very important to us. We worked really closely. I really worked closely with Louis during the 4.0 versioning process on a number of issues. And then with Stephen, it's been more related to our work on platforms and terms of service, which is also something that's really important to Wikimedia, and making sure that their content, their CC licensed content, can be uploaded to different platforms.
And Stephen, can you tell us, I know there's probably a long answer to this question, but the short answer for our guests, why it's so important for Wikimedia to release things under a Creative Commons.
Yeah, so Creative Commons is really at the core of how Wikipedia works. We take the principles that has proven very successful for open source software and apply them to writing an encyclopedia. So unlike other websites where you give Facebook a license to use everything you post, when you post something on Wikipedia, you're giving the world a license to remix it and improve upon it, and that's how Wikipedia articles grow every day.
Well, I'm sure we're going to talk more about that as the show goes on. But let's talk about something that's been much in the news lately to kick off the show, and something that Sarah's been noodling about on Medium, as well as many, many others, trying to figure out what to do about ad-blockalypse. Let's talk about ad blocking. So I guess what the whole current ad blocking discussion is, it's just the latest move in the cat and mouse game between consumers who would much rather not have to deal with ads in their life, whether in an online platform at their desktop or laptop, whether on their phone or any other mobile device, or whether on, their sofa watching TV. There have been countless technologies over the years that have attempted to rescue consumers from being subject to ads, and they've been met with various degrees of success or failure. Replay TV comes to mind, which was famously driven into bankruptcy over litigation about its ad blocking. So the latest development is that Apple, in the latest version of its OS, is building ad blocking into Safari in order to speed up people's experiences on the mobile web. And this has got many people's knickers in a twist. So, Sarah, why don't you give us your take? You wrote a great piece on Medium about the back and forth and the interests at play here. Where do you come down on it?
Yeah, so I was actually really nervous to write this piece because so many people have written about ad blocking, and I guess I have kind of a simplistic view on it, which I'm always kind of skeptical of. So I'm skeptical of myself, but I still, even after writing the article, still agreed with myself, which that doesn't always happen. I don't know about you, and sometimes when I write something, I'll talk myself out of it. But basically, I was reacting to this whole notion that there's some sort of an ethical dilemma for people when they're deciding whether or not to use ad blocking. In particular, there's a podcast that I really like. It's on WNYC. It's called Note to Self. They had an episode called The Ad Blocker's Dilemma: Sell Your Soul or Destroy the Internet. And it was all about this kind of apocalyptic vision of the internet once, there's more and more uptake of ad blocking. And to me, it just struck me as honestly just really silly. I think I don't want to ignore there are serious implications to the ecosystem, and certainly things are going to change on a large scale. But the simple kind of decision for me or any other consumer who's deciding whether or not they want to block ads, I think it's silly to kind of act like there's a moral dimension to that. I think it really comes down, for some people, they may decide that they don't want to use ad blocking because they know that some of their favorite sites make money by ads. But for people, most people aren't going to take that into account. It's really a micro level decision based on, the limited time that you have online. Do you want to have to worry about ads? And I think it's a perfectly rational thing to say, no, I don't. So that was kind of the thrust of my piece. I was just really focusing in on this question of whether or not we need to feel really guilty about the decision to use ad blocking. Because I think I don't doubt that it's going to change the landscape, but I don't think that the world's going to end. I think things are just going to change.
Yeah, I agree with you. I think that ultimately, as the cat and mouse games continue and consumers continue to find and companies who serve consumers continue to find ways to make ads go away and give people a more pleasant experience that way. And we can talk about whether there are ads that enhance your experience or not. We probably should. But from a policy standpoint, from a legal standpoint, I'm curious to know what all of you think about what lawmakers will make of this debate. It seems to me it could go several ways and on both ends of the spectrum. On the one hand, you could have people very strongly advocating that there should be legislation and regulation that protects your ability to manipulate the software that you're using, whether it's your browser, whether it's the software that's baked into a set-top box, et cetera, to customize your experience. And then on the other end of the spectrum, you may get arguments on the IP front. I know that there have been arguments in the past that argued if you're manipulating our content that we're serving up to you, and that includes ads, you're infringing our IP rights, whether it's on a business economics front that folks need to be able to support our business model, and we should have protection for that. Stephen, what do you think? Do you think that lawmakers will wade into this, given that there are strong and polarized interests on both sides?
Yeah, so I don't know if I can say if lawmakers will wade in, but I would be suspicious of any of these policy attempts to fix the ad blocking problem to be particularly successful. If I look at like do not track and the other things that kind of policy and technologists have tried to use to set standards on giving users more choice about what they see or about when they're tracked on the internet, it's usually compromised in a way that doesn't really give consumers meaningful choice. And if people don't have a choice, then they will start, finding a pressure valve. And I think ad blockers are sort of that pressure release. They find a way to get around the things they don't want to see.
Right. And Virgil in IRC is raising an excellent point, too, that on mobile plans, you're paying for every bit of data that comes to your device. And one of the things that's in the news lately is Verizon's super cookie that is written up at Gizmodo by Julia Ongwin and Jeff Larson from ProPublica. So they obviously are wanting to let people know that this is happening and wanting to raise awareness of the privacy implications of this. What seems particularly problematic based on their analysis here is that it will be baked into your Verizon mobile experience. They call it a little noticed announcement from Verizon. Verizon will begin sharing the profiles from its hidden identifier that tracks users on mobile devices with AOL's ad network, which monitors users across a large portion of the internet. So they're worried about how well people can be identified and tracked based on the marriage of those two services, and also worried that because this is part of Verizon's whole mobile strategy, it doesn't seem like there is an opt-out for people on Verizon's system. I don't know if that's true on a browser-by-browser basis or how exactly that will work. iPhones, obviously, are something that Verizon services, so I don't know how that jibes with Apple's latest stance. Anybody have more insight on this? Lewis?
I don't have a whole lot of specific insight. I will say that there's enough control when you're the service provider, right? When you're giving people their entire internet connection, you can reach in and do a lot on a technical basis to track people, right? There's only so much that the phone vendor, Apple or whatever Android phone you're using, can do to control that. So it's it is a little scary, the amount of control they can have there. I have a fair amount of sympathy for the publishers here. I think actually one of the reasons why we have this problem is that web browser vendors failed to figure out how to allow publishers to make money, right? The app stores and now Facebook and Apple's news tools. It's not clear that they've found a perfect solution to that problem, but they are at least trying to solve that problem, right? And the web browser vendors never did. And so what we got instead was this complete disaster area of ads that are many times the size of the rest of the page, super cookies, the whole 9 yards, right? And that's all because the browser vendors sort of failed to step in and try to find some medium. I think Google's announcement yesterday of they're calling it AMP, Accelerated Mobile Pages. I think that's a really interesting one to watch because it's the first time somebody's trying to make a solution that reaches some kind of reasonable compromise between performance and, frankly, the ability to make money as a publisher on the internet.
Right. That will be really interesting to watch and does seem to be, directly responsive to Apple's move here. Stephen, what do you think about getting back to what government and lawmakers might do? We've seen the FTC clamp down on AT&T when it attempted to put restrictions on quote unquote unlimited data users. If Verizon's going to insist on serving ads and having super cookies and everything else for its users. Do you think that could be a regulatory problem, given that they're paying for data and may not wish to pay for ads?
Yeah, I mean, I think it'll come back to the transparency that Verizon has with their users and the choice that they give the users to opt out of things like this. Reading through the stack of papers you get when you sign up for a cell phone doesn't provide meaningful disclosure to most common people. I think even lawyers struggle to read through that sort of text, and I think it's going to come down to what sort of options they give and how they explain it to their users when they sign up.
Right.
Yeah, it reminds me, one of the things I read before I wrote that piece on Medium was, I forget where it was, but a really interesting point about how, the thrust of this whole, we have a moral obligation to watch ads and not block them, is that there's a bargain that we make that, we'll suffer through the ads for you to serve us free content. But the problem is that we don't know the terms of the bargain. We have no idea. Sometimes it's buried in privacy policies. Most of the time it's not even there. Privacy policies are so broad that they basically say they could be tracking anything. So people have no idea what it is that they're agreeing to. I thought that was really interesting. And I guess to me, that's a reason why there wouldn't be, or I would hope that there would never be legislation that would prohibit ad blocking, because then you're really forcing consumers into something that they just can't possibly understand or even know the terms if they would like to. So.
Right. Rock Twist in IRC is chiming in that according to him or her, Verizon injects it, being its super cookie, I would think, at the network level and not on the phone. You can opt out, but you must do that on their site, and they don't make it obvious. That's the kind of thing that regulators don't tend to like. I've been really interested to see that the TiVo has jumped back into the marketplace with something that it hopes people will buy as a standalone set-top box. I know they've partnered with, now I've lost track of what companies are using TiVo technology to run their set-top boxes, but I think one of the satellite companies does. So we have now a box that's called the TiVo Bolt. It's $299. It has a 500 gigabyte hard drive to record things. There's a $400 option with a terabyte hard drive that's available now. And what is also there that people love, and that Dish has been through with its Hopper service, is, well, in a similar way, not probably exactly like this. This is skip mode, which lets you scuttle through ads with the press of a button. They're no longer requiring even a 30-second advance button. This just ad skips. It works only on recorded shows with defined commercial blocks, except local shows and sports. So it's back. I don't know, what sort of traction it will get, but there has been a back and forth in the entertainment industry about the acceptability and legality of this kind of technology. And I'm wondering, Sarah, if you think this latest salvo will come under attack.
It's hard to imagine that it's going to be as disruptive as it would have been 10 years ago, because so many people, I was just thinking about the only time when I watch television that I'm ever subjected to commercials is sports. So it would completely not change my television watching at all, just because we also watch almost everything through Netflix or Apple TV, and just never see ads. So, under that theory, I guess I can imagine it'd be less likely to be controversial. So, not really change things as much. And which also makes me wonder about how much consumers would really get out of this. But there are certainly millions of people that still watch network television. So maybe
there are, and if you record the show, you can still skip ads, but you have to be you develop this strange and esoteric skill of knowing exactly when to push the button and when to push it again to try and miss the ads in a precise way. Unfortunately, has no application to any other arena of your life. But as someone who records on their DVR a lot and does not have an ad skipping feature, I've gotten really good on the button of the remote. And our whole family is, because that's how we watch TV, is tend to record it and then skip the ads. So it'll be, incrementally better for users who want to abandon that esoteric skill. What do you think, Stephen?
Yeah, I mean, I really like the kind of cutting edge tinkerer culture that exists. Whenever someone comes out with a new gadget, I'm a fan of the people who their immediate reaction is to break it open and see how they can improve it or what they can do on top of it. And I think tools like Chromecast are really changing the way we connect our computers to our television. And I would just be so concerned about using copyright law or other forms of like terms of service or something to make a legal barrier between tinkerers and their device. And I think that has to allow people to skip commercials and figure out new things they can do when they record television.
Lewis, are you going to try the Bolt, or how do you enjoy your broadcast media?
Like Sarah, I'm mostly a Netflix, except for sports person these days. And I admit I've even started watching less sports. I'm a huge sports junkie, but I've started watching less sports specifically because there's that sort of, I don't get to watch it when I want to watch it. It's just less convenient. I mean, philosophically, I'm very much with Stephen. The more we can tinker, the more we can, more we have control over these things, sort of the better it is on balance. I suspect, though, the publishers are going to continue to keep moving, and I say publishers very broadly here, right, to include TV. They're going to keep moving towards platforms that we have less and less control over, because that's going to give them more and more ability to make money in a hyper-competitive world, right? That's my fear for the web, right? Is that it's not about, my worry is not legislation. It's not that Congress is going to come in and say ad blockers are illegal. It's that Congress is going to come in, is that technology is going to move such that ad blockers are irrelevant because you're consuming most of your content in apps where ad blockers don't work, right? And because that's where publishers are going to publish their stuff if that's where they can make money. That would be a sad future, but that seems to me much more likely than actual legislation.
Right, and that's definitely one way the future could go. Getting back to a point we raised early in the discussion, are there other ways that things could go where ads are no longer things that you care so much about blocking, number one, or that ads are so insidious and hidden and subtle that the government has to step in and require disclosures to people so that they know that they are being advertised to? What do you think about that, Sarah?
I think that's definitely a possibility, and probably a really likely one, that people are going to get better and better at ads. And I don't know that it necessarily has to be insidious, but I think it has to start being something that people actually want to see. I think this idea that we are forced to see content that we don't want to see seems like a bad business model to me. So to the extent advertising can get better and maybe that means hiding it, but I don't think it necessarily has to mean hiding it. I was thinking about it. Actually, before I wrote the piece, I was thinking about how there are definitely times where I like ads. So, for example, we're going on this trip to Asia next week, and I, would like seeing ads that are hotels and different things to do. That sort of. There's very much times where we're actually looking to be sold things. So I guess I don't think it's necessarily going to be horribly deceptive. But I do think that ads are going to get better. I don't know how long it will take. That being said, yes, there will probably also be times where people will be confused about what's an ad and what's not. I think, though, consumers are going to get more and more skeptical, maybe. I think we already are, especially, you read magazines now and almost everything in there is paid for, or at least I'm always suspicious about recommendations in magazines because you just don't know what's been paid for and what hasn't. And I think that's going to be increasingly the case, for better or worse.
What do you think happens? Because obviously the ads that you're talking about, the ones that you want to see, the ones that are helpful, those work the best when the person, company, villainous institution serving you ads knows a heck of a lot about you and has your data stored securely or otherwise. Where do you think that all goes?
And that's the rub. That's the really, that's where it gets really messy. And obviously I don't want them tracking everything I do to know where I'm going next week. That sort of thing is much easier though, because you do a single search on TripAdvisor, for example, and then they know that you're thinking about going there. And that seems more innocuous as opposed to something I did on, some completely different site, and then you start seeing it elsewhere. So I think it's just the creepiness factor and trying to cut that down. I'm certainly not a fan of having data collected and shared across providers to the extent possible, although I know it happens all the time.
Right. Stephen, Wikimedia sort of doesn't head-on confront this issue because it is supported in other financial ways than by advertising, but it may need to consider this issue at one point or another, right? Anything could happen in the future.
Yeah, anything can happen in the future, but Wikimedia operates under a very clear set of values and principles that sort of guide the decisions that we make as an organization and that our users make on our site. So Wikipedia doesn't run ads not only because it's good for users' privacy, but also because Wikipedia is about being a neutral, reliable source of information, and Wikipedia is very transparent about who edits articles and where the information comes from. And having sponsored content or big banners across the top would not only affect the users, but it would affect the users' trust with the content that they're reading in the articles. And that was a decision that the Wikipedia community made very early on, and one that both the organization and the contributors are very deeply committed to. But I think the conflict that Sarah's hinting at comes up outside of the advertising space anyway. Whenever someone wants to build a feature on a site, they need to understand the users, and figuring out a way to learn about users that gives users choice and isn't problematic from a user's perspective is actually technically difficult. So I have a lot of sympathy for advertisers and people who are trying to just deliver content that users want and struggling to do it in a way that doesn't creep people out. But ultimately, I guess I have a lot of faith in how people make choices on the internet, and if people are being creeped out by an advertising practice, they will choose to avoid it. And I think ad blockers are part of that. But if you look back through the internet's history, there was an era when there were so many pop-up ads everywhere, and that isn't something we confront today. We have different form of advertising, but I think it's because the obtrusive, terrible pop-up ads of the early 2000s are not a good way to treat users today.
Right, and even if users might take the step of, if they're sufficiently creeped out, not just of avoiding the ads or the site, but of suing over that particular issue, which is what happened to Facebook in its Fraley case that it had to settle. We'll talk a little bit more about that later in the show because there have been some developments there.
Can I ask something here, Denise?
Yeah, absolutely.
You asked about regulation and about those ads that people want to see, right? We know there's some regulation there already, right? The Federal Trade Commission does regulate, for example, it's really funny if you ever read these regulations, they don't say we're regulating Twitter. They say we're regulating a social network that is limited to 140 characters. They regulate how you advertise. If you sponsor some celebrity to tweet about your product, there are already regulations there. They're not super well enforced yet, but the regulations do exist. And I think, it will be interesting to see if the FTC ever gets funded to aggressively pursue those. It will be very interesting to see how that happens and how that impacts. Instagram, I guess, is also the new battleground, right? I think even one of the Kardashian sisters had to do a settlement around something they'd done on Instagram. So it's, the regulation is already to some extent there and already to some extent happening.
Yeah, it definitely is. And there are some substantial fines that can be leveled, but you're right, they have probably not the enforcement resources that they need to police every single instance of the undisclosed endorsement. Let's make high creep factor our first MCLE passphrase for this episode of This Week in Law. We put these phrases into the show in case you are listening for mandatory continuing legal education credit or some other form of professional education credit. Some oversight boards like to have some way to demonstrate that you actually watched or listened and didn't just put down episode 323 of This Week in Law on your roster of compliance materials. So there you go. We do that for you. If you need more information on seeking professional education credit for the show, go to wiki.twit.tv. Find our This Week in Law show page there, and we've got a 50-state roundup for folks in the U.S. of lawyers in the U.S., how they might go about requesting credit in their jurisdiction. Lewis was telling us before the show that it's good to remind people, too, that Wikimedia does not own every wiki product or even the trademark to the word wiki. So when we have wiki.twit.tv, that doesn't necessarily affiliate us with Wikipedia or Wikimedia or anything else. How about Wikipedia, Lewis?
Yeah, trademark enforcement is something that we do, right, as part of why we have a legal department. It's funny, one of the things I always got asked when I was in the legal department was, wait, you guys have a legal department? Why do you have a legal department? And then I'd list the 10,000 things that group does. And, trademark is certainly one of them. So.
Mm-hmm. Good. All right, well, let us move on to a different topic. Let's move into Lewis's past for a bit and present. Let's talk about copyright. So, Lewis, once upon a time when you were among the ranks of practicing lawyers, you worked for a well-known firm called Greenberg Traurig. Am I saying that right? It's hard to decide if it's Traurig or Traurig.
I think it's Traurig, but honestly, I'm not sure anybody was ever really sure outside of the Miami office.
I only know one lawyer there these days, Ian Ballin, who writes the incredible definitive internet law treatise and is a great guy and has been on the show before. But they represented Google in the Oracle versus Google case. And the interesting thing to note about that case, speaking of back and forth and cat and mouse, Google won at the trial court level, Oracle appealed, and it won. And then Google tried to take the case up to the Supreme Court. And earlier this year, the Supreme Court declined to take it on. So it's going back to the district court with instructions from above at the federal circuit that APIs are copyrightable or can be, and that the court can do what it will with that. Procedurally, am I getting that right, Lewis? And you want to try and ballpark what happens next?
Yeah. Procedurally, that's right. The interesting angle there is that at the trial court level, the court asked the judge whether or not the court asked the jury, whether or not Oracle's use of the APIs in question. whether Google's use of the APIs in question was a fair use. The jury split on that, so there was no verdict there. The judge then found in his ruling that since the materials were not copyrightable because they were functional, the jury's decision on fair use or lack of a decision on fair use was irrelevant, and so it'll be going back to the judge, to the court, on this question of fair use. Is Google making a fair use of these now definitively protectable Oracle APIs? And that's going to be, I think, actually one of the fascinating questions is whether or not that's even a jury question. It's pretty unusual that the trial judge, Judge Alsup, sent that question to the jury in the first place. So it'll be interesting to see if he decides to do that again in this case.
Right. I see where you're going with that. What generally gets given to juries is anything where there's a dispute of fact. So you would see a judge asking a jury, did the party do X, Y, and Z? Not is this fair use, which is more of a legal question. It is a little more of a legal question.
It is a little more of a legal question. It will depend on how he frames it to the jury, right? As I'm sure you know, there's a 4-factor test for fair use. You could imagine, especially now that this is the only issue, you could imagine him asking about each of those factors and then perhaps using that for his final decision. Right. It's it's definitely an unusual circumstance. It'll be interesting to see how that plays out.
So Oracle and Google get to gear up for trial on this case again, but interestingly enough, the Supreme Court decided not to weigh in and get involved in this question of whether APIs are copyrightable or not, at least not at this juncture. The Supreme Court might want to see a split on that issue in the federal courts below it before it wades in. But as you pointed out, Lewis, you highlighted that over at SCOTUS blog, they've been pointing out a lack of IP-related cases that the court has decided to take up for this term, in stark contrast to last year, where there were quite a few, and in years before that. And no one seems to really get why that is the case. Do you have any guesses?
I don't. It may be in part that it doesn't break down along the court's normal ideological lines. That may make them a little more conflicted. They also, at least in the patent space, a little less so in copyright, but certainly in the patent case, frankly, I think they've been in a little over their heads, right? They are... They've made a lot of rulings that I agree with because I'm not a big fan of the current patent system, and they've substantially weakened the current patent system. However, you can do that in a coherent and structured way, or you can do that in a way that leaves things sort of a mess that all the other courts have to pick up after, right? And I think, frankly, they've been doing a little bit of the latter. Their rulings have not necessarily been very well structured. There's been quite a bit of, I don't really like it, I'll know it when I see it kind of rulings. And, I wonder if they're hearing some of the criticism there and maybe deciding to back out a little bit, stay away, let things settle, let the dust settle. Again, especially in patents, right? I think their copyright rulings have been a little more reasonable. I don't always agree with them, but at least as a matter of readable decisions that actually make sense, they're doing better in copyright than they are in patent.
Right. Well, here in the Ninth Circuit, we try, our court famously tries to give the Supreme Court fodder for its docket. So I'm sure that will continue on. Stephen, any thoughts about either Oracle versus Google or the Supreme Court?
Yeah, I am, of course, a big fan of fair use, and I think that keeping a really robust fair use doctrine is important for a lot of the stuff that happens in internet culture. But I do have some concerns long term about treating fair use as something for APIs. I sort of I hope to see Oracle v. Google settle in a way that just allows people to continue to develop cool open source software.
As counsel for a website that I'm sure gets a lot is probably saying it mildly, of DMCA takedown proceedings. Do you think that the recent Ninth Circuit case, the Lens versus Universal case, will impact your analysis of things, or does it kind of leave things to the party? This is the case we've talked about on the last several shows that is new from the Ninth Circuit and imposes a duty on those who seek to take down material under the DMCA to consider fair use first and whether it should in fact stay up because of fair use. Do you think it impacts websites, or is this all on the parties?
Yeah, I think it's a step in a good direction. You said that, you know, to put it mildly, we receive a lot of DMCA notices, and I think you'd actually be surprised to take a look at the Wikimedia Transparency Report. We actually receive very few DMCA takedown notices relative to our size, and that's partially because Wikipedians are very vigilant about proactively removing material that isn't public domain or properly Creative Commons licensed. So the things that get escalated to the legal team's desk are usually kind of obscure edge cases and often international questions. So the actual DMCA case law is something that we don't have to rely on in the vast majority of situations. Wikipedia is strict about copyright law, or the users are strict about following copyright law and ensuring that Wikipedia is freely licensed and able to be relicensed for others to use. They're even more sensitive to fair use analyses. So whenever something on Wikipedia is put under fair use, it's usually gone through a lot of vetting. So I'm glad that we have a little bit more backup when we have to return to someone who sends us a DMCA notice and explain fair use law.
Wow, that is really interesting and good to hear, and positive for you as a member of the legal team that some of it is dealt with. It sounds like quite a bit of it is dealt with at the community level. Lewis, could you speak to that at all as the community manager? Do you think that Wikipedians are just more up on these issues than the general public, or they have the resources to be able to analyze these issues better?
I think Wikipedians, there's just a very strong culture of caring about this, right? We're coming up on our 50th anniversary, and which on the one hand makes us pretty old in internet age, but also makes us a little bit younger than the free software movement, right? A lot of our early founders were and early editors were intensely involved in the free software movement, and so they were very thoughtful about and very serious about intellectual property, right? On the one hand, we wanted to give away what we create, but on the other hand, we want to respect the rights of others. Just as we would want them to respect our rights. And so, that culture's been sort of baked in from the very beginning. We have extensive policies in English Wikipedia about fair use, extensive license information about all the images that we have. It's just part of the culture. It's just part of, culture of one of the ways in which we're continually improving our content is by continually making sure that it's, not a violation of the rights of others.
So fair use is hard. It's not always easy to tell. It's really hard for courts to tell often whether something is fair use or not. So I'm fascinated by the notion that these decisions are playing out among the Wikipedia community members. And I'm wondering if you ever do you feel that a good balance is struck? Do you ever feel that people are maybe too quick to take things down? It seems to me like it would work far better than a content ID algorithm.
I mean, Stephen has heard me rant on this many times. I think if anything, sometimes the community is in fact too strict, right? I mean, one of the criteria of educational use, and certainly if you take the broader view of transformative use, we are clearly transformative in almost all of our uses of this content. So I think if anything, sometimes the community is a little too aggressive. Actually, the best example of our aggressiveness is often not necessarily about fair use, but about term length, right? We have a lot of material, especially in Commons, which is our repository for images and multimedia. There's a lot of that material is in the public domain because it's been out of copyright, right? It was published before 1923 or in other years, depending on your jurisdiction. And the community is often very aggressive about looking at the rules of other jurisdictions, interpreting those aggressively to see whether or not something is public domain. For example, in an interesting case, a doctor who's an active contributor to the project wanted to put up some x-rays to help illustrate some images of medical articles. In his interpretation, and to be frank, my interpretation of American copyright law, there's no creativity in the creation of an X-ray, right? It's 90 degrees to the body. You know, you're looking for a very specific part of the body, and the purpose of that is purely diagnostic, not creative or artistic. So I would say that, at least under American copyright law, no copyright adheres in an X-ray. The community decided to be more aggressive about that. I forget. I think it was maybe a German case that they looked at and said, "Oh, well, I don't think that's public domain, right?" And so the X-rays were taken down. And I think that's actually a loss for the project, right? But at the same time, I'd rather. I mean, how do you balance? It's good that people are aggressive, right? It does save us a lot of potential damage to the project if people weren't as aggressive. So that's just part of the cost of being who we are, right? I like to joke that every other top 10 website has more lawyers than we have employees, and we couldn't make it work if we didn't have volunteers, most of whom are not lawyers, stepping in and making these calls, right? So I try not to second guess them because they're acting in good faith and trying to do the right thing for the project.
Right.
One thing, can I ask a quick question too?
Yeah, absolutely.
One thing I've wondered about, I wonder how Wikipedia deals with this, or Wikimedia. We hear sometimes kind of this notion that you shouldn't include materials under fair use in CC licensed works, larger CC licensed works. The reason being, if they're going to be used internationally, fair use doesn't apply everywhere, and it makes it harder on international reusers. And so I'm curious, obviously Wikipedia English doesn't take that position, but I wondered if you've ever had that sort of a discussion with your community, and if there are other Wikipedia languages that handle it differently in terms of their own exceptions and limitations. I mean, not fair use specifically, but.
I mean, part of how we handle that is simply by making sure we label everything that is fair use pretty clearly with the fact that we're using it under fair use and what our rationale is, right? So that if you were, say, printing a book in Germany, you could filter those out if you wanted to, right? Printing a book in Germany based on Wikipedia. But that's, you're correct to point out that this does vary from language to language. It's, Denise, Sarah, not all your listeners may know this, but it's important to understand when you're talking about Wikipedia, it's not one Wikipedia, right? The rules on English are different from the rules on the German encyclopedia, are different from the rules in the Japanese dictionary, for example. We do enforce some very high-level meta rules through our terms of use, but those are really stopgaps, right? The primary rules on content are done through the community, right? So, so that's going to vary a lot from community to community, and fair use is one of those areas where we don't have necessarily consistency, right?
Interesting.
And
Stephen, was there anything you want to add? Sorry.
Yeah, I mean, if you look, I was just scrolling through some different language Wikipedias. If you look at the Wikipedia article on Godzilla, you'll see a lot of fair use images throughout it in English, but the German Wikipedia has opted to illustrate the article with a statue from a photograph that someone took and released under a Creative Commons license. So the different language Wikipedias illustrate things in different ways, and some of that is influenced by the copyright laws in those countries.
And again, is that left on a country by country basis to community members rather than in-house counsel for Wikimedia?
Yeah, the policies on what pictures they will accept when you upload them is something that's decided by users and administered by users. And Wikipedia just sort of operates in this consensus-driven environment where the Germans can decide to the German language community can decide to run their project slightly differently than other languages, and we get sort of this like laboratories of experimentation going on where you can compare and contrast how different Wikipedias work, and there's lots of interesting lessons there.
I should add, Denise, that it's not just to make all of your lawyerly heads explode. It's not the German nation's Wikipedia, it's the German language's Wikipedia. So their copyright policies are based on a combination of German, Austrian, and Swiss copyright law.
Wow. Yeah, that would further complicate things as well. All right. Now would be a good time to thank our first sponsor for this episode of This Week in Law, which is FreshBooks. If you're a freelancer or you run a small business, chances are your very least favorite part is rummaging through your receipts and trying to keep track of your expenses, creating, formatting, and sending invoices, and the worst, tracking down customers who don't pay you on time. FreshBooks solves all those problems for you. It's the super simple cloud accounting software that's giving thousands of businesses like yours the tools to save time billing and get paid faster. You may not know, but in my other life, when I'm not sitting here having wonderful conversations like the one we're in the middle of on This Week in Law, I practice law. And I practice law as a solo practitioner. I have a home office that I work out of and no staff. So the financial side of the business is all up to me. And thank goodness for FreshBooks, because it really just makes it dead simple, extremely accurate, extremely easy to use when it comes to both sending out invoices, receiving money from clients who have paid me, and also when it comes to tax time. It manages all of those tasks seamlessly. Even if you're not a numbers person, and I'm really not, I find that I can create and send invoices. Seriously, it takes me about 10 minutes a month to get my monthly accounting duties done. You can organize your expenses easily and get them captured on your invoices, get yourself reimbursed. It's easy to track your time, which is something we do in the legal profession, and many other professionals do too, where you're billing by the minute or the hour for your time. You can even do this on mobile devices. And with their automated late payment reminders, you don't have to email or call your client who just hasn't quite gotten around to paying that last invoice. They're going to get a little tickler right from FreshBooks without you having to intervene if you set that up. You'll wonder why you didn't start sooner. If you have questions, help is free forever, and you can always count on FreshBooks award-winning support rock stars to go above and beyond whenever you need a hand. Getting started is simple, and it's totally free for 30 days. Go to freshbooks.com/TWiL. And don't forget to enter This Week in Law when they ask how you heard about us. That helps us quite a bit. Start your 30-day free trial today. And thank you so much, FreshBooks, for your support of this episode of This Week in Law. Sarah, let's talk about Creative Commons licenses for a moment, and a change to the share-alike license, or if it's not a change, it's at least an announcement about the license and the way that it works with the GPL version 3. Why does it matter that Creative Commons licenses be compatible with other kinds of open source licenses?
Yeah, so it's kind of an interesting thing about copyleft licenses that they operate to create these silos of content, because the whole idea of the licenses is that if you adapt the work, you have to apply the same license. And so by definition, unless there's something else built in, that means that that content can't be remixed with other copyleft license content, which is kind of counterintuitive, because a lot of those licenses are really, created with the same purpose in mind and are very, very similar. And so several years ago, I actually can't remember, it was before my time, with the last version of CC licenses, we created a mechanism to get around this, which is that you can adapt share-alike licensed content and apply what's declared a CC compatible license to it. We have never actually used that for the 3.0 licenses. But with this most recent version of CC licenses, which we published in 2013, we've now declared 2 other copyleft licenses to be compatible. The first was the Free Art license, which is a French license, very, very similar to Creative Commons. And then now, just this past week, the GPL v3 was declared compatible. And the reason for that, it's kind of interesting, because Creative Commons really doesn't endorse the use of its licenses for software. But in this particular case, the reason behind it was there are more and more situations where content gets used with code in a way that it's kind of impossible to separate out the two in the final product. And so in those cases, we heard from a lot of different people that compatibility was really important. And so now people can use by SA licensed images and different content and incorporate it into GPL v3 projects and apply, just continue to have GPL v3 apply to the entire project. So it'll be interesting. It just happened, I think it was yesterday, although we've been working on it for probably 2 years now. It took, we went through a long public comment process and analysis and work with the Free Software Foundation to make it happen. And hopefully, I'll be really curious to hear how take it actually gets. There was a lot of excitement around the announcement. So it'll be interesting. And I'm curious to hear what Lewis in particular thinks of the announcement too.
Yeah, in a prior life when I worked for Mozilla, I rewrote Mozilla's public license, which is also a form of copyleft. And like Sarah, spent a lot of quality time talking with the Free Software Foundation, who are the stewards of the GPL, about how to make the 2 licenses work together. So mostly all I can say is congrats, Sarah. This is not... There are very few people who appreciate all the complexity and nuance that you all had to do to pull this off, and so I appreciate it. Yeah, I think in practice, what happens with things like this is that the folks who are trying to who are contributing to open source are by and large trying to do the right thing, right? But they're not lawyers, and so they look to organizations like Creative Commons, like the Free Software Foundation, to help them understand what it is that they're doing, right? And instead of digging into the nuance, it's sort of more of a blessing of, oh, okay, FSF and Creative Commons said it's okay, I'll go ahead and do it, right? Some details always get lost in that, right? So I'm sure we will see a bunch of cases pop up of people not paying attention to the details, but trying to do the right thing for the authors. And I think that's what's actually important. And so something like this that enables the creative people to go ahead and do their work, think less about law and more about what it is they actually want to do, I think that's a good thing. So,
yeah, I think that's exactly right. There's this balance between wanting to care about the legal details, especially as stewards of one of the licenses, and then also just keeping in mind kind of the broader point of what we're doing and how the content's being used. And so this is kind of an attempt to strike a compromise, but that respects both. We're not disregarding the kind of legal details, but at the same time, we're keeping in mind what the point of it is.
Right.
And I'm interested with the 3 of you on our show today, what you think sort of the state of free and open license adoption is. Obviously, Wikipedia is, as Sarah was saying, one of the biggest users, if not the biggest user, of Creative Commons licenses, and has made some unique decisions about how it wants to have a participatory environment and a freely shareable environment that other organizations may not always make. Are you guys seeing a lot of parallels? Do you think that we're in stasis with this kind of thing, or is it, it's been quite a few years now that these sorts of licenses have been in play, and I'm just wondering about your opinions on their penetration. Can we start with Stephen?
Yeah, I am. I'm pretty optimistic about both the present state of open source and the future direction it seems to be heading in. I'm seeing more permissive licenses being used, which means it's very easy to find open source code and use it in your projects. I think that these permissive licenses are not damaging the health of the open source projects that they are protecting. Ultimately, the open source license's goal is to ensure that the project can continue to grow and thrive and sort of be shared around. And I think permissive licenses, there's some skepticism early on whether or not they could be good for a project long term, because they put very little condition on how they could be used by companies that were more closed. But permissive licenses are all over GitHub and used around the internet. I live in an age where I can have open source on my phone. I can have open source running and powering many of the websites I visit, and I think we're moving in a very, very interesting direction.
Lewis, anything to add?
I totally. The single biggest trend in software is definitely away from copyleft and towards permissive licenses. It's just there's a bigger state of trust, right? 15 years ago, when we started doing this kind of stuff, it seemed sort of almost unreal that we could give our stuff away and people wouldn't exploit it and they would contribute back. The fact that that's almost routine now has really helped permissive licenses grow. I think the other biggest really interesting trend to me that I'm keeping an eye on is the growth of open data, right? Open source software is almost old hat at this point. Open cultural works like Wikipedia, that niche is fairly well understood. It's not huge, but it is. But it continues to grow steadily, and is fairly well understood. The interesting action is entirely around open data, right? Things like OpenStreetMap, which is the world's biggest open map with over 2 billion data points. Wikidata, which is our project for structured data for things like. It used to be if you wanted to ask us what's the population of Berlin, you'd go to the Berlin article and read the first sentence, which said Berlin is the capital of Germany and its population is such and such, right? So a human being had to read that. We're now turning that into structured information so that there will be a way for a computer to say, what's the population of Berlin, and get the exact number instead of a sentence, right? We're licensing that under a Creative Commons license, Creative Commons 0. And we're going to see more and more governments are publishing open data sets about their populations, geographic information, things like that. I think where that licensing story goes is going to be really fascinating to follow, because there's going to be more and more of that as more governments and more businesses realize that that's in their interest. So,
yeah, and if there had been an open data repository of X-rays, maybe your Wikipedia issue would have come out differently. Anonymized X-rays, of course. All right. Any further, Stephen? I was interested when you raised my eyebrows about the comparatively low number of DMCA notices that Wikimedia Foundation fields. Anything else that might surprise us that you deal with on the IP front that you think we might not know about?
Yeah, I hope you have had a chance to read through our public policy site. We recently launched a site, policy.wikimedia.org, that has statements on Wikimedia's position on copyright, on privacy, on intermediary liability, and censorship, and other issues that come up a lot. Wikimedia is about sharing knowledge with people and ensuring that people have access to information around the world. And this policy site explains how some legal and policy issues impact people's ability to create Wikipedia articles. They need to find accessible sources to read and then cite them in articles. They need access to the internet to post those and share them. And then we rely on things like Creative Commons and the public domain to allow them to be remixed elsewhere around the internet. So this site has a lot of background information that you might enjoy reading if this is something that's interesting to you.
Yeah, absolutely. Yeah, I was just alerted to the existence of that this week. It's brand new, right? It's only a fledgling.
It's been last month. Mm-hmm.
Yes. So it is one of our resources of the week. We always give a tip and a resource of the week on the show. And this week, you need to check out the Wikimedia public policy page, because there's some very interesting, good material there for any website to take into account. I think it really highlights how big a role policy issues play in any online-oriented business that's operating today, or it's hard not to think of Wikimedia as a business and more of a cultural organization, but whether you're in the business of the .org or the .com, all of these issues are going to be important to you. Let us move on, speaking of policy, to talk about some important policy developments this week. One thing that might impact you at Wikimedia is this decision out of the European Court of Justice. I think we talked about this case a while back before it was resolved, Sarah, that involved the question of the transfer of data out of the EU to the U.S. It's called the Schrems case, Maximilian Schrems versus Data Protection Commissioner, that dealt with data that I believe was in Ireland that was being moved to the U.S. And the surprising thing that the court did here, there was a safe harbor arrangement in place that had been approved by the EU that allowed U.S. entities to transfer personal data about EU citizens to the U.S. under limited circumstances. But the European Court of Justice has decided that that safe harbor is not valid. And so if you're going to be transferring data, you're going to be doing so at your peril as far as EU citizens are concerned. This applies to transfers as opposed to actual storage. I think a whole set of other considerations apply if you're not transferring, if your servers are just located outside of the EU. But is this something, Stephen, that impacts Wikimedia, do you think? Since, you, in addition to all of the material that populates Wikipedia, you have information about your various Wikipedians that you need to pay attention to, right?
Yeah, it's definitely something that we keep our eye on. Our user base is around the world, not just located in one specific country. But Wikimedia as an organization actually collects relatively little data on users. So we have a privacy policy that goes into a lot of detail on what we collect, when we collect it, and everything about it. And this is something that we don't just kind of publish from the legal team. It's something that we publish in draft form, accept comments on from our community. These comments influence our practices inside the organization and ultimately the policy that we end up following. And that means that our users are part of the decision-making process on how Wikipedia works technically and what our privacy standards are. And many of the users who participate in those discussions are from outside the United States.
All right, Lewis, anything to add about EU data being transferred to the U.S.?
It's actually, this is just an interesting wrinkle for those of you who are super DC, policy and jurisdiction nerds. This ruling, formally speaking, does not affect us because the Safe Harbor Agreement is enforced through the Federal Trade Commission. And the Federal Trade Commission is explicitly prohibited from enforcing things against nonprofits. And so the Safe Harbor, we would have loved to have formally been a part of the Safe Harbor arrangement, but because the FTC cannot enforce it against nonprofits, we can't join it. So we had to seek other routes to make sure we were legally compliant. So this doesn't, as a technical matter, doesn't impact us. I do think it's an interesting. As I think not all your listeners may know, a big part of the reasoning driving the European Court's decision were the Snowden leaks of documents showing how extensive NSA surveillance was. And so the European Court relied on this NSA surveillance as part of the reason to overturn the Safe Harbor Act. We're doing we are currently litigating against the NSA along with a bunch of other publishers on exactly that issue, right? So we're protecting our users' privacy not just by collecting a fairly limited amount of data about them, but also by fighting in court to address some of these surveillance issues, again, on behalf of our users outside of the U.S.
Right. There is some irony or strange twists of fate to what you just pointed out, Lewis, that the EU is obviously concerned with protecting and keeping secure the personal information of its citizens, but it was a leak that gave them the information that they based their decision on here. So I guess leaks have their value in certain circumstances. Any thoughts, Sarah? Sorry, go ahead.
Oh, I was just going to say, also those leaks show that European governments are also spying on their own citizens. So I did, right. While I agree with the sentiment of the court, the inapplicability of that to their own citizens and their own governments, I found somewhat sad.
Yeah. Sarah, any thoughts?
Yeah, the only thing I was going to say is I think that what Lewis points out is really important is that the NSA surveillance issue was critical here, it sounds like, to the European Court of Justice's opinion. And the reason I like that is it gives, a business reason for American companies to push back on government surveillance. I think a lot of them were doing it anyway, but this is just another reason why it's actually, in their commercial interests, let alone for policy reasons. So that seems like a good thing.
Okay. Stephen, anything you want to add?
No, I think Lewis covered it well.
All right. I'm trying to think of how we can cobble together a good MCLE passphrase from this particular discussion. Something about leaky boats and safe harbors. Let's just make it that. Leaky boats and safe harbors will be our second MCLE passphrase for this episode of This Week in Law. Still trying to wrap my head around what's going on with the TPP, but from the news coverage this week, it appears to have reached a point where it is very close to being adopted. And now Congress gets to take a look. I don't know that any of the rest of us do yet. Lewis, any insights you want to give us on the TPP and where things stand?
Well, again, I haven't read it either. I read fewer cases these days, obviously, since it's not my day job. But this one, as I'm sure you know, haven't read it for different reasons. There have been some leaks. There was a wiki leak of it this morning, and from what little I saw in my Twitter feed, it suggested that there was a retroactive expansion of term limits, right? And that's something we just find pretty reprehensible, right? We rely on material in the public domain. There's research that shows that Wikipedia articles are richer when there's related material in the public domain, and so something that attacks that is of deep concern to us and to our editors. So that's certainly something that we'll be keeping an eye on, though how much opportunity we'll have for impact on that, it seems unclear at the moment.
Right. And just so our listeners know and understand why we talk about the TPP on This Week in Law, it obviously affects things well beyond the scope of what we generally cover on our show here, but it does have some intellectual property provisions. So we think, so we're led to believe from the leaks that have come out to date that could be problematic, and Lewis highlighted one of them just there. Any thoughts, Stephen?
Yeah, someone in the chat, Virgil, just shared a link to an article discussing the impact of the TPP on New Zealand. And one line in there that I found very interesting was an estimate from the New Zealand government that the change in copyright term from 50 years to 70 years would cost $55 million per year. It's a relatively small country with and it shows the big impact of increasing copyright term due to the expense of licensing and the loss of public domain material for future creative reuse. And I think we've seen with the Copyright Term Extension Act and in the United States and other treaties, just a slow but reliable increase in copyright term over the years. And the TPP is just another step in that direction. And I think in order for policymakers to really have a good kind of holistic copyright policy, they need to understand the value of the public domain that's being encroached upon every time the term of copyright gets extended or gets kind of sort of standardized in a really long life plus 70 years term. And I think Creative Commons does a great job explaining the value of the commons and the public domain. And I hope that we have more conversations about what we lose every time we extend copyright terms so that we can make really smart decisions about when term lengths need to go up.
And this is reminding me, Stephen, to circle back and ask you, I wanted to ask you before when we were talking about works that are available on Wikipedia and in the Wikipedia Commons, and how you determine what's okay to put and leave there and what's not. How do you deal with the orphan works question?
Yeah, so Wikipedians need facts. So if a material is uploaded and it's not clear who the author is, they sort of err on the side of not including something that's potentially a copyright infringement, which means that there's a lot of orphan material that isn't being put up on Wikipedia. Now, the EU has been kind of struggling with how they deal with the orphan works problem, and there have been proposals about requiring some sort of due diligence before an orphan work could be used. But I don't think any of them will fully, any of the orphan work solutions that policymakers are thinking about will solve the concerns that Wikipedians have, and unless there's some sort of like legal protection for using material that has been orphaned. It just means that like copyright term extension, we're really losing something every time we fail to protect the public domain and the commons, and orphan works is just another example of how that happens.
All right, Sarah, anything you want to add about recent news about the TPP and what it may or may not contain?
No, the TPP just kind of remains a mystery, and I think that's probably one of the biggest problems about it is that there isn't transparency, which means that there can't really be, an educated debate about all that's within it. So I hope now maybe will be the time that we actually get some answers and can actually, debate what's really in there rather than just worrying about it. I mean, there have been leaks in the past, and it sounds like there are going to be leaks already today of more of it. So we'll know what's really in there and can do something about it. I thought one of the articles in the show notes was really interesting. I hadn't realized how much pushback. I mean, there's huge pushback within my little world in Twitter and the IP world, but I didn't realize it was more broad-based. I guess Hillary Clinton's now come out against it as well. So it'll be interesting to see how it all plays out. I'm just glad to know that there's going to be a debate about it.
Yeah, I'm sure that there will be. And for folks who want to read the article that Sarah referenced or anything else that, has sort of underpinned our discussion today, we make all of our discussion points public. I'm using a service called TagPacker to do that these days. So if you go to tagpacker.com/user/thisweekinlaw, noteworthy in light of our earlier discussion that the reason I used to use Delicious for this, but Delicious got so flooded with ads that it was not only unpleasant to use to manage our bookmarks, but I'm sure it was unpleasant for any of you who wanted to go and look at our lists of discussion points for each of the shows. So made the decision to switch to TagPacker, which for the moment seems to be ad-free. It's probably worth mentioning in light of our earlier discussion that Delicious does have a business model that they're experimenting with where you can pay a premium and get rid of all the ads, but I don't actually know if that does it for your users as well. People viewing the pages that you have bookmarked, it might. But it was a pretty hefty price, and I decided just to switch to TagPacker instead. So check it out, see if you like it or don't. But all our discussion points for all of the shows are there for you to check out. There was one other policy story we had bookmarked for today, since we had our gaming law show last week, and we were talking about the fantasy sports world and how they are wading into esports. I just thought it was funny to see this week that they appear to be undergoing a sort of insider trading scandal where the companies have had to put out statements saying that basically trying to assure people that they're not their employees are not misusing information. I can't really wrap my head around how people insider trade or bet based on information that as the operator of a fantasy sports organization. But apparently it's possible that there are things that employees at people like DraftKings would know that would enable them to go to a competitor site and place bets that would enable them to win money. So the fantasy sports world has been dealing with that this week. I don't know if anybody, I just thought it was funny to mention and bring to people's attention. Anybody want to weigh in on that, or shall we move on?
I'm just awed by the amount of ads in those sports that I mentioned earlier that I watch for these sites, right? That is not a legal comment. That is not legal advice. Simply, man, that's a lot of ads.
Yeah, they're definitely fighting for market share, those ones that are out there. So making a misstep like having their employees misuse information, probably not a good thing for them to be involved in, given they're trying to rise to the top in a very cutthroat way. Let's move on to a privacy story. So this is one of those, that was bound to happen kind of stories. We've talked many a time and had many long discussions on This Week in Law about the right to be forgotten, recognized by the Court of Justice of the European Union. There is a gentleman who is the reason that decision came down in May of 2014. His name is Mr. Costeja. Maybe I'm saying that wrong. Maybe I am not, but I'm going to go with it. And he had some links to information about him that were coming up in connection with a search for his name that he was hoping would not be associated with his search results. And his desire to have that information disassociated with a search for his name led to the whole right to be forgotten thing. However, what has happened now because that case is so well known, and because it was his particular case that triggered the law, it has backfired on him, because he has had to go to the Spanish Data Protection Authority and ask still that this information be removed about him. But now that this case has become the seminal case for the right to be forgotten, it has such a role in public life, it has such public notoriety, and is of such public importance that the Spanish Data Protection Authority has said, I'm sorry, no, even though you are the person who led to the right to be forgotten doctrine in our Court of Justice of the European Union. We're going to leave these links up because too bad, now you are, in a sense, a public figure. So the right to be forgotten in his own case, advocating for it, just wound up in more exposure, or the Streisand effect, as you might want to refer to it. So again, just something interesting to note, recent decision from the Spanish Data Protection Authority. Sarah, any take on this?
Yeah, the Streisand effect was exactly what I thought of. It's like a legal version of it. I mean, the thing that comes to mind for me is that this is just yet another one of the downsides to being a plaintiff in any lawsuit. I think about that a lot with my husband's work. He works for the state and defends the state in tort litigation. And, these discrimination cases, just amazing, the stuff that can come out about a plaintiff in those cases. And it just makes me think, you have to really, really want to bring a lawsuit if you are willing to go through that. And I guess this is kind of an IP version of that. I'm sure, I don't know if he didn't think about this. I mean, the Streisand effect is pretty well known. Maybe he didn't, it seems like he does care though. I was going to say maybe he didn't care, but obviously he cares. So it is kind of an ironic, but I think it's probably the right result. But
yes, I'm guessing he didn't play the chess game that many moves out. Louis, any thoughts?
Well, sometimes plaintiffs are driven by emotion and anger, not by not by the chess moves, right?
Right.
So that I suspect that may be the case here. I was actually just, it's interesting. We have an extensive article on this case in English Wikipedia. I'm trying to find an equivalent one in the Spanish Wikipedia, and I haven't found it yet, which I think is interesting, and I'm actually will be very curious after the show to dig into why that is. I also saw somewhere on the wiki, but I can't find right now. You mentioned the Streisand effect being well known. It of course goes by different names in different countries, right? Depending on who the local celebrity it was who first fell into the trap. And again,
really?
If I can find that after the show, oh yeah, right? Because a lot of, in Spain, do they really know who Barbara Streisand is? No, but this will probably be the Costeja effect in the future in Spain, right?
Yes.
And I know there's one in, I believe Russia was the other one that somebody very specifically pointed out to me. They had a different name because we were actually communicating on one of our public mailing lists about this. And someone said, I have no idea what the Streisand effect is. And someone else chimed in with, oh, in your country, it's blah, blah, blah. And it was like, oh, it makes sense, of course, right? It's a common problem, and yet at the same time also would not go by the same name everywhere, right?
Oh, that's very funny, and of course makes perfect sense. Stephen, any thoughts?
Yeah, it's just so hard to predict how something like this will be covered in the media. And I think that, to me, is just a reason to give media more freedom when they cover stories. But, there's always a balancing act there. And it's I have a lot of sympathy for people who are kind of caught up in media stories that they perhaps didn't predict themselves being involved in.
Right.
Yeah. It's definitely... yeah, you have to feel a little bad for some of these folks, right? It's such an interesting mix to observe who's taking these things down, right? Because sometimes it's Sometimes it's a wealthy person who just doesn't want their name tarnished, right? But sometimes I became aware of one case where it was a cop who was involved in the arrest of a criminal and just didn't want his name associated with that, right? Not because he'd done anything wrong, just that it drew attention to him in a way that he was uncomfortable with, given who the criminal was and that sort of thing, right? So it's not. It's not as black and white sometimes as I think American privacy, as sort of the American dialogue about this would like it to be.
Right. This is written up nicely at Stanford's Center for Internet and Society site by Miguel Peguera, who points out that the very article that Mr. Costeja sought to disassociate with a search on his name is the very first result when you search for his name in Spain. And it looks like it's going to remain that way. So sorry, Mr. Costeja, but if it's any consolation, you may have a whole effect named after you in your country. Let's move on to a privacy-related story that involves kids.
I don't think I've ever seen that bumper.
Oh, yes. This is a creation of Sando, and we have his permission to disclose that that is his daughter, Daenerys, in the bumper. So I think she's adorable, and I love her name. So I mentioned the Fraley versus Facebook case and settlement that they're seeking to have approved. This involved Facebook's sponsored stories where without consulting with their particular users or getting specific permission, what Facebook wanted to do was if you were somebody who had liked a certain product or page or whatever, your name and likeness would be featured in telling people that you knew that you were a fan of that thing. So it was a right of publicity kind of issue, use of name and likeness without the person's express consent for commercial purposes. And they never did litigate the case. They're trying to settle it. A class action settlement is pending. Public Citizen has jumped in to object to the terms of the settlement, did so in the middle of last month, because if the settlement goes through as drafted, images of minors will still be used without their consent or their parents' consent in Facebook's advertising. So that's problematic. It's not problematic under COPPA, which deals with using personal information of kids under 13. But apparently, according to Public Citizen, 7 states have their own laws that governs the use of minors' images. So that demographic between 13 and 18, or maybe 13 and 17, right? When you're 18, you're no longer a minor. Without their parents' consent, that would violate the laws of 7 states, says Public Citizen. So they're weighing in and trying to get the settlement altered in that way. Sarah, any thoughts on this?
Yeah, well, so I guess first I should admit that the only thing I've read about this case is this one Public Citizen post. So that being said, it seems like Public Citizen is right here. It sounds like the settlement, Facebook just agreed to include language that said that minors represent that their parents consented to use of their names and images in advertising, which to me is just a complete legal fiction. We all know it's legal fiction. And so it's absurd. I mean, to me, that is absurd that would be enough. So I don't know. To me, at least my initial reaction is, yeah, that's not real consent at all. That's just us pretending like there's consent.
Right. I don't know. I mean, there's so much pretending about kids on websites anyway. What was the stat a couple of years ago? There were over 5 million people under the age of 13, I think, on Facebook. It was determined. Somebody did a study and found that. Of course, obviously, Facebook is obligated to kick them off if it finds out that that's the case. But there's the rub. So these issues continue to plague sites. Do they plague Wikipedia, Stephen?
Yeah, we maintain, again, I said earlier, we maintain very little data about our users. I mean, Wikipedia has user accounts, but it's not a social site like Facebook. So people very rarely disclose their age, and people are usually there to have an account so they can record the edits they've made. So we don't run into this issue so much per se, but the bigger picture question about how terms of service relate to children is something that I think sheds a lot of light on one of our conversations we had earlier about this kind of social contract around ad blocking. It's really applying this notion that we have an agreement with a service provider where they give us Facebook, and in exchange we give them some information about ourselves and some rights to use our identity. I think that contract is a little absurd sometimes. Using children as an example kind of shows that those problems. And I'd be really interested to see some of the kind of contract, intro to contract 1L black letter law applied here. And I think Facebook is looking to avoid that.
Right. Does Wikipedia have any policy about minors or kids under the age of 13? Or do you have any problem with having youngsters contribute to Wikipedia?
No, we don't have a policy against people contributing, but of course, if someone is disclosing private information about themselves on Wikipedia, they're usually doing it in a public forum, and it's usually inconsistent with Wikipedia's rules. So people can get their accounts banned if they're sort of accidentally sharing too much information about themselves or breaking some Wikipedia norms.
Right. Okay, at the end of the show here, I did have one other topic that I thought we could delve into just for a few minutes. Sarah was writing about her experience traveling and being away from the family. Every now and then we talk about work-life balance. It doesn't have too much relationship to what we've been talking about today, except for it is a legal issue that comes up in the technology industry in particular, because it's both known for being a hard driving, hours of caffeinated sessions at the office kind of environment, and also gets a lot of flack for not having women in both managerial and influential kinds of situations. And a lot of that, I think, comes down to how the legal and policy issues of how companies treat their workforce. So maybe just for a couple of minutes, we could touch on these things. And this would definitely qualify as other. That may be my favorite of our bumpers because it's just so random. All right, so let's start with you, Sarah, since you wrote a bit again on Medium about travel and family and the balance of those delicate worlds. Tell me how you think things are going in the technology industry on the work-life balance front these days.
Well, I think in some ways, I'm completely spoiled because I work, full time from home, which just is a life-changing thing. Even though, my son is not at home all day, but I don't have a commute to contend with. And when I turn off my computer, I'm already home. So right. I think in a lot of ways, I have a completely unique experience, and it's ideal for being, a mom who also works full time. My current piece is about, we have the Creative Commons Global Summit next week in Seoul. And I did a lot of kind of soul searching about whether or not to take, because I was already going to be gone a week, whether to make a vacation out of it. And we ended up deciding to do it. And my husband's coming out. We're only staying 5 extra nights, which to anyone who doesn't have kids probably thinks I'm insane to even worry about it. But that means I'm going to be gone for 12 days, more than I ever have in my son's life. So it's a big deal. And I'm actually quite nervous about leaving, but I think he'll be fine. And I really, I feel good about the decision, and in part because I am here all the time. This is just one instance where I'm going to be gone for just 12 days, but compared to having a career where I was, missing dinner every night, or, because of a 2-hour commute, or traveling constantly, I have nothing like that. So I think I'm really, really lucky, and I think it's an unusual position to be in.
There was a piece also in Medium that Margaret Gold Stewart, who's an executive with Facebook and previously at YouTube, she's done a lot of speaking, she's done a lot of conference attending, and she really got upset about something that she noticed, and that seemed to be that whenever women executives, the CEO of YouTube, for example, got put on panels, they seemed to be asked about, how do you have so many children, and how do you manage to maintain it all? How do you manage to do your job and also be a mom? When that question doesn't seem to ever get thrown, or if not ever, at least with the same frequency, get thrown at male panelists at these sorts of events. So her offense to this was, we shouldn't be having this disparate treatment in the panel scenario. And I think, she says, women should just not answer these questions, that it's not relevant. You don't need to know whether Susan Wojcicki, I think that's how you say her last name, how she manages her family life, if we don't need to know what all her male colleagues do too. I tend to flip that on its head and say, I think we need to know how everybody manages their family life, right? Because it's hard. It's like fair use. It's not an easy thing to work out. You have to have a lot of support. You have to have a lot of creativity. Sometimes it's crazy. Sometimes things get out of control, but whatever strategies you're employing might be, whether you're male or female, might be helpful to others and inspirational to those who really want work and family to occupy the roles of importance that they both deserve. So what do our male panelists think about all this? Lewis, do you think that there's a problem here? And what do you think of Margaret Gold Stewart's solution?
Yeah, I mean, there's obviously a problem, right? I mean, it's just shameful the way we treat a lot of women in this industry as sort of, singling them out for that kind of treatment is just clearly a throwback that shouldn't be part of how we have this dialogue anymore. Solutions for that kind of thing are hard, right? That's why change is so hard. I almost want to say that the solution is to say, I will answer this question if you promise to ask that of the next man on the panel, right? Or the next guy you interview, right? So that you're not being quite so disruptive, but you're making it really clear to the interviewer that the interviewer has a social obligation as well, right?
Right.
It's something I'm thinking a lot about right now. My wife and I are trying to have kids, and I am, managing, at least one person on maternity leave right now, and a lot of people with kids, and it's also, I think, very interesting. It's a very different context when it's not lawyers, right? Because since I'm no longer, for better or for worse, I think a lot of my friends who are lawyers who have have become parents, they sort of braced themselves, right? They knew there was a lot of misery coming their way, and have chosen various paths to help them deal with that. And the rest of the tech industry, I think it's more subtle, right? Like the biases against parents are less obvious. So a lot of people get into the industry not fully understanding exactly how difficult that balance is, right? So they're not necessarily as prepared, and it catches some of them more off guard, which is, it's unfortunate. It shouldn't catch them off guard because it shouldn't be hard, right?
Right.
But it's it's still a real problem in the industry.
There are a couple of great pieces in our discussion points. We don't have time to go through them in too much detail, but Anne-Marie Slaughter, who has written famously about this issue in the past, has a fairly recent piece in the New York Times called A Toxic Work World, and she's also written a book that has just come out called Unfinished Business: Women, Men, Work, Family. In fact, her New York Times piece is straight out of the book. It's an essay from the book. And then a complimentary piece published in The Atlantic is by her husband, Andrew Moravsik, maybe is how you say his name.
I know it's a great piece. I know I don't know how to say it.
Yeah, great piece. And talks about how, he is the primary parent in their family, and the stigma that goes along with that to this day. We think here in 2015 we have come so far away from that, but no, he's here to tell us it's alive and well. Stephen, at Wikimedia of all places, I would think that kids and dogs are running around the workplace rampantly, and that every guy who's thinking of having kids is taking the maximum paternity leave possible. Is that what you see?
Yeah, there are certainly kids and dogs around the office. I think working on a legal team in a nonprofit is something that, as Sarah said, is just a huge privilege. So I feel very lucky to be here. I also, though, see sort of firsthand a lot of the challenges that Wikipedia has had with gender inequality and the contributors. And at the end of the day, it's part of our mission is to try and collect the sum of all knowledge. And I think someone around the office very elegantly said that's not a mission we'll ever achieve until we can welcome the sum of all people to contribute their knowledge. And there's still a really tough, persistent problem there. And I think a lot of that problem, just having talked to people who have both struggled with this and had to kind of overcome it in the Wikipedia space, is unconscious. People don't really understand the full context of the situation, and that's why I'm very, very thankful to have the sort of writing that you link to in the notes for this podcast, because this reading will help us kind of understand unconscious bias as well as the conscious ones.
Right, absolutely. We have one more sponsor to thank for this episode of This Week in Law, and that is Braintree, which is code for easy online payments. If you're a mobile app developer, you have to check out Braintree. It is the payment solution used by companies like Uber, Airbnb, Hotel Tonight, Living Social, and Munchery. Braintree scaled with these companies from early stage startups to the successful companies they are today. So Braintree can scale with your business too. Braintree has made the payment experience in these apps seamless and almost magical. And now you can add a similar experience to your own app. With excellent customer service and simple integration, Braintree gets you ready to receive payments quickly. And Braintree's continuous support plus fast payouts means you'll be prepared as your company grows from your first dollar to your billionth. Braintree is helping solve the problem of mobile cart abandonment by offering a best-in-class mobile checkout experience. Check it out for yourself. Braintree gives you a full stack payment solution, support for all payment types your customers might want. Start accepting PayPal, Apple Pay, Bitcoin, Venmo, cards, and more, all with a single integration across all platforms, with superior fraud protection, customer service, and fast payouts. To learn more and for your first $50,000 in transactions fee-free, go to BraintreePayments.com/TWiL. Thank you, Braintree, for your support of This Week in Law. All right. I think the work-life balance conversation is an important one. The gender bias overtones of that too, and one that we'll continue to bring up from time to time. But wanted to bring your attention to the recent writings on the topic because they're good ones, and the more that we're aware of them, the better the situations become. So we mentioned one of our resources of the week. That is the Wikimedia public policy page. Another one, we don't often bring you job listings, but there was one that caught my eye that I thought would be definitely of interest to people who listen to this show, those with law degrees anyway, that Facebook, at least earlier this week, who knows if this position has already been filled, but they're looking for IP counsel to deal with notices and takedowns under the DMCA, to develop and apply policies and practices arising under the Digital Millennium Copyright Act, to coordinate incoming IP reports. I suspect that the volume that they get is probably more than the ones we've been told Wikimedia is getting and reporting in its transparency reports. But it looks like a fascinating job. If I were a younger single person, I'd certainly be throwing my hat in this ring. It is, you need and if I were living in Menlo Park, where you need to be, or somewhere nearby, you need a law degree, membership in at least one state bar. You don't have to be a member of the California bar. You need 4+ years of relevant legal experience with in-house experience, a plus, et cetera, et cetera. If you look on our Tag Pecker page, it is one of the many things linked there. So wanted to bring it to your attention. Looks like a fun one. Also, we have a tip of the week for you that relates to Facebook as well, and others who give you buttons that you might apply to your site. The Facebook like button is specifically dealt with. But what you might not know is under COPPA, which we mentioned earlier in the show, this is something you should be concerned about. If you are someone who is brave enough to operate a child-directed website, so you're actually going to comply with the requirements of COPPA, which many sites decide not to do and only cater to those 13 and above. But if you're wading into the COPPA arena, you actually have to be concerned, even if you're putting a plugin such as a Facebook like button on that site. In many instances, you may have to get specific. You may have to give direct notice to the parents and get specific consent to whatever information is being gathered about your child if they click on that like button. There are some exceptions that are dealt with under COPPA, but for tip purposes, just be aware. It's not something that maybe you would think of. You think you're doing everything else right under COPPA, and it may not even occur to you that putting a like button on your page could be a legal trigger, but it could, and it's one of the things that the FTC has more information on in its extensive resources about COPPA compliance. So with that, we're going to go ahead and wrap up this show. It's been so fun chatting with you, Louis and Stephen. Thank you so much for joining us. We're very excited about Wikimedia and its new public policy page, everything that you guys have been up to. Louis, I'll start with you. Is there anything other than the public policy page that you want to leave our viewers and listeners thinking about or aware of before we go ahead and end the show?
Just that I'm very lucky, and I think we're all lucky to benefit from this community of 80,000 active contributors who volunteer for us every month. So I'd like to thank them for making my job possible, and I hope all of you will take an opportunity to thank them too. So,
yes, that's awesome. Stephen, how about you?
Yeah, thanks so much for having us on. And if anybody listening out there sees something wrong on Wikipedia, just go ahead and fix it. We're always looking for more editors.
Yay! All right, Sarah, great having you on the show again as well. Any news on your front other than your upcoming travel?
Yeah, not really. That's the big thing on the radar. Creative Commons Global Summit next Thursday, Friday, and Saturday in Seoul. And Stephen will be there. Lewis, you're not
Yay.
making it this year, are you?
I'm so sad I'm not making it. And this is actually the first I've heard Stephen is making it. I'm jealous. You two enjoy without me.
Yeah, we're running a
Very
session
cool.
together. Yeah.
Yes. Anyone who can be in South Korea, be sure and get over there and say hi to Stephen and Sarah. We'll wish you all the best from back here at home. And thanks so much, all of you, for your great participation today and contributions to the show. And thank you, our audience, for tuning in with us. If you've done so starting at 11 o'clock Pacific time, 1800 UTC on a Friday, then you've been watching us live. Yay, congratulations. But don't worry if that doesn't work out for you. That's when we record the shows and you can play along with us live. But if you'd much rather watch at a different time in a different venue, just head on over to twit.tv/TWiL. Our entire archive of shows is there. This very show that we're recording live now will be there just as soon as it is done and posted. And we have all kinds of resources there for you about ways you can watch the show, ways you can subscribe, etc. So we encourage you to check that out. We also encourage you to get in touch with me and Sarah between the shows. Sarah is Sarah P at twit.tv. I'm Denise at twit.tv. You can find us on Twitter, Facebook, Google+, all great places to hit us up, let us know what you thought of the show, other topics that you'd like to see us cover, other guests you'd like to see us invite, anything at all about the show that's on your mind, let us know. We love hearing from you. We couldn't do the show without you. We're so glad that you join us week after week, and we will see you next week on This Week in Law. Take care.